lets.
Yes, indeed.
We have that copied out, and there are two further authorities that we are bringing before the court.
Yes.
One is DB and the Chief Constable of Police Service.
Yes.
The other is Regina Z and another.
Yes.
Shall I attribute numbers to those for the purposes of the
We've been given very smart little clips with.
So I think
DB would be 26, Z and Hackney 27, Let's 28.
28, and then my learned friend has produced two more cases, which I think the reason for bringing these to our attention is because they refer to lets.
I'm certainly aware of Bayer, in which this court said that Let's paragraph 118 is a useful encapsulation of the law. Is that one of them?
Yes, Bayer is one.
We've given you Bayer and also Mr. Justice Fordham's decision in JCWI. That was the product of our searches as to when Let's has been cited.
Yes. All right. Mr. Justice Fordham didn't say it's all a lot of nonsense, did he?
No, he made a finding, I think, of a Let's breach in one aspect.
Right. Thank you. Well, if you've got copies of those for us,
I think my learned friend's got copies.
Have it all
and so that
at one go. They'll be,
they can be
29 and 30.
Good, yes.
We've also found a reported version of Let's, so you
2015
might want to use that at tab 28.
Yes.
So I suggest reported Let's can go in at 28.
Yes.
Bayer at 29 and JCWI at 30. I'm afraid, I'm sorry, we don't have the smart clip.
Right. Yes.
So my lord, in light of exchanges following my citation of state shilling yesterday at the beginning of my submission, there are two authorities that I'm obliged to bring to the court's attention in that regard. First being DB, which is now at tab 26 in our authority finding. Decision of the Supreme Court and speech of the late Lord Kerr. It was an appeal that went to the Supreme Court following a judicial review over the question of the police service for Northern Ireland was sufficiently aware of the full range and scope of its powers. If I could take my lords to paragraph 78 of the speech. And probably the best approach is to invite my lords to read from there to the end of the speech. So that's paragraph 78 to 81.
I don't know the case at all, except possibly as a newspaper item, but is this a second appeal from a judicial review in Northern Ireland?
Yes.
Yes. Yes, so you lay emphasis on paragraph 80 in particular.
I lay paragraph on, yes. The citation from the United States Supreme Court is striking, my lords, that the rationale for deference to the original finder of fact is not limited to the superiority of the trial judge's position to make determinations of credibility. That's in paragraph 79. And at the foot of that page, as the court has stated in different contexts, the trial on merit should be the main event rather than a tryout on the road.
Yeah.
For these reasons, review of factual findings under the clearly erroneous standard with its deference to the trier of fact is the rule, not the exception. And it is, in fact, to that citation, that quotation from that judgment, that Lord Kerr referred in the fifth line in paragraph 80 that the Lords referred. The vivid expression in Anderson that the first instance trial should be seen as the main event rather than a trial on the road of residence, even for a case which does not involve oral testimony. And then towards the bottom of that paragraph, the case for reticence on the part of the appellate court, while perhaps not as strong in a case where no oral evidence has been given, remains cogent. In the present appeal, I consider the Court of Appeal should have evinced a greater reluctance in reversing the judge's findings than they appear to have done. Now, that was in
Yes.
That was in 2017. The Supreme Court returned to this question of the appropriate role that the role that the Court of Appeal was obliged to fulfil when considering an appeal against a judicial review. In last year, in Z in the Hackney Borough Council, that's tab 27. And that was a case on the question of the judge's assessment of the proportionality question in relation to an allocations policy in respect of housing. If I could take, my lords, to paragraph 56 of the speech of Lord Sales, please. This is with reference to the decision of Lord Justice Lewison in the Court of Appeal in this case. And it invite my lords to read from the entirety of paragraph 56, please, which goes on to the next two pages.
Right. That's what Lord Justice Lewison said in this court, and
Yes.
what did Lord Sales go on to say?
Paragraph 74, my lords.
Yes. Yes.
So it's not sufficient that an appellate court might think it would have arrived at a different conclusion had it been considering the matter for the first time. Although the word wrong is taken from what is now CPR Rule 52, paragraph 21, which is concerned with the powers of the Court of Appeal, certain other appellate courts, but not the Supreme Court, arguments for a limited role for an appellate court are of general application, and the same approach applies at this level.
Is Lord Sales 74 talking about the whole spectrum of decisions of this court, or is he talking about a review of a trial judge's decision about proportionality or not?
The specific point in this case, to which he was addressing his mind, was the question of proportionality. And he was essentially, as my lords have seen, saying you don't reconsider it as if you were considering the matter for the first time. Now, the reason why proportionality was being debated in this case is because it had been thought that because of the Human Rights Act, questions of proportionality had to be reassessed every time a matter came before the court. So that unlike in the general run of cases, if one was dealing with a proportionality question, the Court of Appeal was bound to assess it for itself. That's why, that was the argument that was being put. Essentially what the Supreme Court is saying in this case is, even with questions of proportionality, deference must be shown to the findings of fact by the trial judge. And they must only be overturned on appeal if the appeal court is satisfied that they are wrong.
But I lived with, for years, with the concept of a spectrum, that the notes to 5221 in the White Book cite DuPont and Lord Justice May, but it's not rocket science. That you have a spectrum of types of first instance decision. At one end, you've got pure points of law where the trial judge's conclusion is no better than anybody else's, because it's simply a pure point of law.
Absolutely.
At the other end of the spectrum, you've got cases which depend on the credibility of oral witnesses and the judge. The judge hears all the evidence, decides who's telling the truth, and it's very difficult to shift his or her assessment where it's based on the credibility of all witnesses. Yeah. And you've got a whole range of cases in between where it's not a pure point of law, and of course the present case isn't a pure point of law. And one type of case is where a judge makes sometimes called a multifactorial decision, weighing up a whole lot of factors.
Yeah.
Was and proportionality as an example, taking all these things into account, was the decision proportionate or not? And an appeal court is entitled to take a different view, but it ought to accord a good deal of respect to the judge's balancing exercise.
Yes.
And I don't read either of the cases you've shown us as departing from that. Saying that the first instance trial should be seen as the main event rather than try out on the road, or as Lord Justice Lewison said in another case, it's a dress rehearsal. It's not a dress rehearsal, it's the one and only night of the show. Doesn't really help.
Well, it does help to this extent, my lord, because I do maintain the submission that, and with every due respect, your task is not to decide this case for yourselves as if this case was coming before you at first instance. Your task is to decide whether the learned judge below, in any of the findings of fact that she made or inferences that she drew from those facts, was wrong.
Yes, but Mr. Mathias, I think we understand that. Speak for myself, certainly I agree with that. But that doesn't relieve one of saying, as my Lord has said, that there is a spectrum of approach depending on the nature of the trial below.
Yes.
So where the judge below, for example, has heard no oral evidence and is operating on witness statements and contemporaneous documents,
Yes.
then clearly there is an easier route to saying we disagree. You still have to say the judge was wrong.
Yes.
It's not enough to say we would find a different view, but it is a much easier route to say the judge is wrong because we are as well positioned with the material as she was.
Well, yes, but my lords, one just has to be very careful about the approach one takes, because very easy to slip into the mindset, oh, well, we're in as good a position as she is, so we'll decide what we'd have done, and if she did something different, then she's wrong.
And if we did that, that would undermine the finality or the weight of the original finding. So, with that caution, is there anything more that you need to say?
Well, I would just finally draw your attention to the the very short judgment of Lady Justice Arden Lady Arden in the Hackney case, which is on the final page of this report.
Well, she emphasises, she re-emphasises the point you've submitted to us, which is that there is not a, as it were, clean sheet of paper, start afresh consideration of proportionality by the appellate court. I was a member of the divisional court in that case, and there were a number of factual contests at that stage which fed the proportionality assessment. And what Lady Arden is saying in those three short paragraphs is that that was an exercise legitimately undertaken by the divisional court and not inappropriately redone, as it were, by the Court of Appeal. She's emphasising that that's an appropriate approach in principle, I think.
Yes, I mean, it's that penultimate sentence, the point made by Lord Justice Lewinson, is not changed by the fact that the appellate court might have reached some other conclusion.
That's right.
So the fact that this court, with every respect, might have reached some other conclusion on the facts is not determinative of the question.
No, but the focus here surely is this, isn't it? Especially when we're considering irrationality, which is one of the contentions in the claim, that the focus falls not so much on primary findings of fact, or even primarily on inferences, but whether, in view of those inferences, such as they were, the judge can be said to be wrong in her conclusion that the two elements of decision-making we're concerned with were each of them irrational. And that's very much meat and drink, isn't it, for an appellate court in claims for judicial review. Normally in a claim for judicial review, there will not be oral evidence from cross-examination. And normally the facts will be largely uncontentious, as I think we've been told at least the primary facts are in this case. I didn't discern in Mr. Jaffe's submissions a contest to any degree on the primary findings, or factual assessment, if you will, that underlay the judge's analysis.
Well, the findings of fact that are material, we sought to set out in our skeleton argument.
Of course you did, and that's a perfectly normal and legitimate exercise. But what I'm seeking to emphasise, perhaps consistently with the spectrum concept, is that in the present case, not atypically in judicial review, the appellate court is considering whether the judge was wrong to find the error of law she did in the light of the facts as she took them to be.
Yes.
Which is a classic exercise of appellate decision-making for this court.
Yes, it's not of course it's not a question of law. It's essentially a question of fact, and that's the point.
Well,
and the conclusion.
Well, it's within the frame of the principles of law that apply to the concept of irrationality.
Yes, but
we were taken, as I said yesterday, we were taken through the facts because Mr. Jaffe seeks to impress upon us his submission that when you look at the facts that are, as it were, the subject matter on which the analysis rests, the conclusion of the judge that this was an irrational process of decision-making simply cannot be sustained.
Well, that was Mr. Jaffe's, my learned friend's, summary of the facts, but the important facts are the facts that you find in the substantive judgment.
You're entitled to emphasise particular facts and particular inferences of fact in making the submission to us, which you do, that the judge was entitled and right to find that this was an irrational process of decision-making.
Yes.
And that, it really doesn't go beyond that, I don't think.
Well, say that. The question is, you do in my submission have to be in a position to overturn her findings, to conclude that she was wrong. And the meaning of wrong is on appeal is clearly decided, and it's clearly stated in Stachelin, either that there was no evidence to support a challenged finding of fact, or that the trial judge's finding was one that no reasonable judge could have reached.
Well, you're not submitting to us that we're not entitled to look at the facts as they were established below and reach the conclusion that the judge was wrong to conclude that this decision process was irrational, are you?
I'm not saying you can't, my lord, but in order to do so, you would have to either find that there was no evidence to support the finding, or that her finding was one that no reasonable judge could have reached. That's the hurdle.
No evidence to support a finding is rather difficult. Just focus on ground one. The critical question is, did the decision makers, let's bracket the mayor and TfL together, and looking at the main claim, not Bishopsgate.
Yes.
Did the decision makers fail to take into account relevant consideration, namely the special position of taxis and their role in providing assistance to the disabled? Did they fail to take that into account? And the question is, surely, did the evidence before the judge of the documents in existence as at the 15th of May support her finding that they failed to take this into account in issuing the guidance? That isn't a proportionality assessment.
No.
It's a finding that they failed to take this into account. The concept of there is no evidence to support a finding that they didn't take it into account is rather difficult to grasp.
Well, she does explain it with all respect. She explains it with great care in her judgment at between paragraphs 137 and 157. And it is worth, if we're going to look at whether she was wrong in coming to the conclusion that the status of taxis and the importance of taxis to disabled were not taken into account, one has to read those paragraphs with great care.
Yeah, I'm sure we all accept that, Mr. Mathone.
Yes.
I mean, doesn't it come to this? Mr. Jaffe says that on 2 or 3 points of detail, the judge was factually wrong because there was direct evidence or indication that taxis were under consideration. 2, he says, from the context of the evidence, you should infer that they were. 3, he says that the judge's finding that they were not wasn't a proper conclusion on the evidence taken as a whole.
Yes.
Now, wouldn't it be sensible, maybe, for us to move on to you telling us why that's a wrong approach, rather than
Well,
the procedural?
Yes, but I want to understand the rules.
Yes,
Um,
yes,
with every respect, there was no evidence, as the learned judge found, that the status of taxis or their importance to the disabled and the elderly who are incapable of active modes of travel and were dependent on taxis for door-to-door passage, that there was no evidence that those matters were taken into account by TfL or the mayor in the formulation of the plan or the guidance. And with respect to my learned friend, there was nothing that he drew the court's attention to yesterday that went to the opposite effect. Their case is essentially, oh, well, of course we were thinking about that, but there is no evidence whatever that they were. And as the learned judge said, at paragraph 140, the only evidence of the mayor and TfL's deliberations prior to the announcement of the plan was the PowerPoint presentation entitled Recovery Strategy, Active Travel. That's at our tab 34. And we went
but that seems to say that you cannot give evidence of what was in your mind at the time that you issue a document unless you can show that it's all in writing.
Well, if there is no, this is the distinction between an ex post facto justification and a justification that finds that which is evidenced in something that was produced at the time. Normally, of course, it'll be the decision itself. If a material consideration is taken into account, ordinarily it will be referred to or alluded to, or whether expressly or by implication, in a decision or in some documentation that leads up to the making of a decision.
What is the decision that you're attacking?
The plan, and then the plan attributed to the mayor, and the guidance attributed to TfL in respect of the mayor's plan.
Yes, but I understand that. But what Mr. Jaffe says, there is nothing in the plan and guidance that alters the existing policy in respect of taxis, and in particular their use of most bus lanes.
And we disagree with that, and the learned judge disagreed with that. The learned judge.
Where?
Where?
What does she find that the plan and guidance alters in respect of the position of taxis?
Paragraph 144. She's talking about that recovery strategy document, which was the lead up to the plan and the guidance. And her concluding sentence is, reading the recovery strategy fairly and as a whole, I consider it reasonable to infer that TfL did not take these matters into account. Given their importance, I consider that they would have been mentioned if they had been taken into account.
The platform for the conclusion is in the first sentence in the paragraph. The recovery strategy did not refer at all to the long-established status and role of taxis.
Yes.
Right. So that amounts to saying, unless there is an express reference to the long-established status and role of taxis as a form of public transport, it wasn't thought about.
Yes.
So that's a lesson to every decision maker, that every possible factor that might be relevant in established policy has to be mentioned each time a decision in detail is taken.
Well,
is that right? Is that what you're really...
No, but no, it's in the context of her understanding on a plain reading of the plan and the guidance that their effect was to lump taxis together with the general run of motorised traffic. Their special status was lost in those documents. But ignored.
If the guidance amounted to, for example, an instruction that no motor vehicles other than buses were going to be allowed into central London at all, then I would understand that puts taxis out of business. But what I don't understand is what is it that was the change in the position of taxis, which you are entitled to attack.
Well, I think in the learned judge's finding at paragraph 145, it's in the final sentence, my lord.
Yes.
The plan did not mention taxis, but it is apparent that its restriction on cars were intended to include taxis. Now,
yes, but what restrictions?
The suppression of cars, the suppression of motorised transport. They were to be suppressed, and there were to be the creation of roads that were restricted to pedestrians, cycles, and buses.
Well, there's two problems with that, Mr. Matthias, as far as I can see. First of all, Mr. Jaffe points out that the press release of the 15th of May did deal explicitly with taxis, at least to some degree. But secondly, in saying in a very general way that we're going to reduce the number or the volume of cars in central London, does that necessarily mean that we are to an equal extent going to reduce the number of taxis travelling in central London?
Well, one would hope not, and that's why it would have been important.
No. Follow the logic of my question. If I say I want to reduce car traffic,
yes,
and I don't in this document say except for taxis, does it follow that I'm intending, generally speaking, to reduce taxes?
If my lord, if you simply use the word car, yes.
Even though I have an extant policy which is not altered, that taxis have a different status, whether they get to travel in the bus lane at Bishopsgate, they get to travel in most 90-something% of bus lanes in London. I think,
my lord, with respect, one's got to bear in mind that the words used were motorised transport, motorised vehicles, and that, so that it was not, and was clearly not intended to be confined to cars.
Well, but is it a fair inference to say, from the use of the phrase motorised transport, that the decision was taken in the plan that all motorised transport would be treated equally, exactly the same, whether or not they were public service vehicles other than buses, taxis, goods vehicles? Surely,
one thing to bear in mind is that the plan and the guidance were pan-London documents. The bus lane policy is a TfL policy. Now, if one puts oneself in the position of a transport officer in, say, the London Borough of Haringey, they don't have the bus lane policy. He or she, reading the plan and the guidance, why would they regard taxis as being entitled to any special treatment?
Because they know that taxis are a different category of vehicle, treated elsewhere in London and by TfL as having a specific status for the purpose of bus lanes, and they know that taxis have to operate in the way they do.
The special status of taxi, the bus lane policy is particular to TfL, but the special status of taxis applies throughout the capital.
So you say that the transport officer in Haringey, where they don't apply the bus lane policy, will, because of the phrase motorised transport, assume that they're being directed to treat all motorised transport in the same way.
Yes, and that's what's happening. But the Proctor schedule, which is appended to the substantive judgment, indicates the plethora of roads throughout London, and these are by no means all TfL roads, where taxis have been excluded. And that is pursuant to the plan and the guidance. So clearly the learned judge's reading and understanding of the plan and the guidance as ignoring the special status of taxis and effectively lumping just another vehicle on the road, just another motorised vehicle on the road, treating them in that way is how it's been interpreted.
What we've got here surely is this, isn't it? we've got a new policy introduced in the circumstances of the pandemic in mid-2020, which sits alongside several other policy documents, including the bus lane policy. It does not revoke the bus lane policy, nor does it purport to change the bus lane policy. Correct?
It does not. No, it doesn't expressly. It doesn't ignores the bus lane policy.
It says nothing about the bus lane policy. We can agree that.
Yes.
Yeah. It doesn't therefore purport to change it or revoke it.
No. Well, my lord, I risk of repeating myself. It simply ignores it. So
Well, very well. You can say it ignores it, but it does not purport to revoke or change it. It leaves the policy as it is. So far, so good.
Yes.
Yeah.
But bearing in mind that the bus lane policy is not applicable throughout London, and
Of course, you just made that point again.
Yes.
The bus lane policy is what it is, and it stays as it is.
Mm.
Yes. The bus lane policy itself, so far as we can glean from the papers before the court, in a slightly eccentric way, it may be said, is qualified, not absolute.
Yes.
It's qualified, at least in one respect, relevant here, which is that there may be circumstances in which, for operational or safety reasons, I paraphrase, it may not be appropriate to allow taxis to use bus lanes on TfL roads.
Yes.
Thus, there is a qualification in the extant and unchanged and unrevoked policy that allows, for operational reasons or safety reasons, taxis to be excluded from a particular stretch of TfL road. That, of course, would have to be the subject of an appropriate order made in accordance with the statutory scheme. Those are the circumstances in which you're contending it was incumbent on TfL and the Mayor explicitly to say all that, or something like it, either in the policy documents themselves, plan and guidance, or in some extraneous document that demonstrates the decision process. Therefore, we must consider, presumably, whether in the circumstances that was a necessary exercise to make the plan and guidance lawful, or not.
Yes. Was it a material consideration?
Right. That's the dividing line between the parties on this principal point. If we reach the conclusion that there was no need for that to be done in law, your case falls on this ground.
Yes, and my lord will bear in mind that the material considerations that were in play, because of the general nature of the plan and the policy, was not bus lane policy per se. It's the material considerations were set out in the judgment at paragraph 100, namely the distinct status of taxis as a form of public transport, reflected both in law and policy.
Yeah.
And the role played by
Forgive me, Mr. Mathias. We've just agreed, I think, that they are demonstrated in policy, and the policy is neither revoked nor changed.
Yes.
So at the level of, if you like, what I'll call macro or strategic policy, the status quo prevails. But what is done in the plan and policy, policy and guidance, plan and guidance, I'll get there then. Plan and guidance is to invoke, in the circumstances of the emergency, the concept, among others, of the suppression of motorised transport, to permit public transport to function as it must in those emergency circumstances.
Yes.
That's an operational consideration.
If one looks to the judgment of paragraph 139,
Yeah.
She's referred to the powers under which the plan and the guidance were made. under the Greater London Authorities Act 1999. She summarises those in paragraph 138. She then makes this important finding at 139. Whilst the statutory powers and duties confer a broad discretion on the Mayor and KFL, I am satisfied that in making policy statements and issuing guidance on road use, they were required to take into account the potential impact of the proposed scheme on the existing rights of all classes of road users, including taxi drivers and their passengers. These were matters so obviously material that a failure to take them into account would not be in accordance with the intention of the Act. And she refers to the credence case that was adopted by Lord Starman in Re Findlay. My lords will be familiar with that. We have it in the authorities. Yeah. This is a crucial finding, and it's on the basis of this finding that her judgment in this regard was based. If she hadn't decided that these were matters that they were required to take into account, then obviously she wouldn't have found in the claimant's favour on ground one.
Yeah, well, we may disagree with that.
If you're satisfied she's wrong.
Yes.
That's that.
Yeah.
Yes.
There's the point.
If we think she's wrong, we'll disagree with her.
Yes. And if you're satisfied that this finding is one that no reasonable judge would arrive at. That's what wrong means in this context.
Does it? No reasonable judge.
That's in paragraph 33 of Statelin, but the word wrong is on an appeal. That's the basis of an appeal. Either they're wrong in law, as a matter of law. Obviously, if you're wrong in law, then this court has an untrammeled.
It's a bit different from saying there is an inference on the material which was wrong, from saying no reasonable judge could reach such a conclusion. It's not quite necessary to go as far as that, is it?
Well, with every respect, my lord, it is. That's the test. That's the importance of the test. It's a review.
So it's a Wednesbury type
Yes.
test, is it?
Yes. And as I say, one finds that clearly stated in Statelin, and whatever the word wrong is used in the context of an appeal.
These must be the most important cases to have come before the courts, if you're right, in recent years. That in the powers of the Court of Appeal Civil Division, on every appeal which is not an absolutely pure point of law, the Court of Appeal can't interfere unless the judge was Wednesbury unreasonable.
Yes, yes. But it was
and authority for that is in paragraph 33 of Statelin.
Yes, my lord. Yes.
Mr. Messiah, I plead guilty to once an occasion having reached a wrong conclusion. I'd be rather upset if that meant I was an unreasonable judge.
Well, I don't think it's meant to be, in any sense, critical of the judge. It's just the judge has got it wrong. We all get things wrong.
Well, speaking for myself, I think Lady Arden's final paragraph in Z and Hackney sums it up very well. If the court at first instance makes no error, there's no flaw in its judgment, the appellate court shouldn't make its own assessment of proportionality. I would accept that. And there are some balancing exercises, multifactorial balancing exercises, where you really can't say that a trial judge might have come to one conclusion, a trial judge might have come to another conclusion. You don't start again from scratch as though the trial was just a dress rehearsal. But I think to say that this leads to a general rule that you have to show that the conclusion was one that no reasonable judge should reach is rather difficult. But should we move on from theology, as it were, to the actual judgment in this case? And you tell us why Mr. Jaffe's criticisms of it are misguided.
Well, my submissions in terms of material considerations were essentially completed yesterday.
Yes, I think they were.
I would merely urge the court to read again the way the learned judge puts it.
Yes.
And to use the words that we've seen in the authorities, give appropriate deference to the findings of fact that she makes.
I mean, in short, and without seeking to compress your response to the appeal, you are submitting to this court that the judge was right for the reasons she gave.
Yes.
And really that is the essence of your submissions.
Yes.
I'm not in any way, of course, seeking to prevent you, nor could I, making submissions to amplify that proposition, but you are saying to this court that the judge's decision should be upheld for her own reasoning.
Yes. Yes. In terms, I'm speaking specifically now about material considerations.
Of course you are, yes.
Yes. And in terms of her judgment on material considerations, it was careful. She reviewed all the evidence, came to findings that are, in my respectful submission, unassailable in every respect, and came to the conclusion that the material considerations, that's the importance of taxis and their significance to the disabled, had not been taken into account, had not been taken into consideration with the making of the plan and the guidance. They were, but they were obviously material considerations, and had to be. Those were her findings. There's nothing in the plan or the guidance or the documentation recovery strategy to indicate otherwise. And all that my learned friend Mr. Jaffe is left with is the assertion, oh well, if there were other policies in existence, that's good enough. Well, the learned judge held it wasn't good enough. Learned judge held they were material considerations, and they were of such significance to the plan and the guidance that they had to be taken into account. And if they were taken into account, there would have been some record of that.
Oh, well, that's the last one. Is rather important. In paragraph 139,
Yes.
says, I'm satisfied that in making policy statements, let's just focus on the plan for the moment. The plan, rather grandly entitled, appears to be either or both of two press releases, 6th and 15th of May.
They referred to as press releases in this court. They were never referred to as press releases below. My learned friend
Policies,
court
all right.
as the plan.
Policy statement.
Yeah.
So the mayor or any other decision maker in the field of transport says it's my ambition to shift more people into walking and cycling and have fewer in vehicles for all sorts of reasons.
Yeah.
The judge appears to have found that that statement of policy is unlawful unless it says, I bear in mind, of course, that elderly, especially the frail elderly population, can't walk more than short distance. Some of them can't walk at all. That some of the population of London is disabled. They can't go long distances. Every pedestrianised precinct which is created has some difficulties for people who would like to be at the door. All that must be put into a statement or in guidance to the boroughs. Otherwise, it shows that the decision maker has failed to take those points into account. If there had been oral evidence, surely the decision makers, say Mr. Monk, doesn't require the mayor himself, would have said, well, of course we bear all this in mind. Of course, the boroughs know this as well. This is absolutely elementary in any decision about transport. We know all that. We've had special policies about disability for years. Black cabs, unlike private hire vehicles, have got to be wheelchair accessible, and so on and so on. We know all that. We don't have to spell it out in every document we produce. Wouldn't they have said that?
Not in well, that's what they would have said, but the learned judge found that this was not just any document. This was a document which sought to suppress motorised transport, that recommended, urged local authorities to change the roadscape throughout London and to change it by the creation of bus and cycle only roads and lanes. Mm-hmm. In that context, the impact that would have, if put into effect throughout London, on taxis and the disabled, was a matter of such obvious importance that the learned judge held, and it's at paragraph 144, these considerations were clearly relevant, as the proposals would affect the rights of taxis to apply for hire across London and to use bus lanes. Nor did it refer to the travel needs of these people for whom cycling or walking or taking a bus was not a reasonable option and who wished to take a taxi. So the whole point about this plan and it wasn't just any plan and any guidance, it was a plan and guidance that would directly impact upon those road users.
Is there any explicit mention of emergency vehicles of the different categories that there are? Should there be?
I'll check that.
You have to, you see, the point is obvious.
Yeah.
You need to touch every base explicitly in a document
No,
such as this.
no, and I don't think I'm not aware of any road restriction that applies to emergency vehicles.
So does that not need to be said then?
Well, they never. No, I've never come across or heard of a road restriction that excludes emergency vehicles. Indeed, even the restrictions that exclude all traffic are available to emergency vehicles.
So that can be understood without a specific.
That doesn't need to be. No, that wouldn't need to be said. But of course, the taxis and the availability or otherwise of taxis and their effect on the disabled is something quite different. It's those last two sentences in paragraph 144 that encapsulate my lords.
That's concentrating on the document, the
That's the
recovery
recovery
strategy of April, which in fact was not something you were seeking to quash.
No, that's the only evidence we have of the thinking behind the plan and the guidance. We're looking to the plan and the guidance. One goes to 148. That's the plan. And then she goes on to deal with the guidance from paragraph 149 on, and at a conclusion on the guidance, it's a similar effect as at paragraph 153. And then paragraph 156, of course, is important. Her conclusion was these matters were so important in the context of this plan and this guidance that if they'd been taken into account, they would have been mentioned, and they weren't. Unless I can be of any further assistance on the material consideration point,
that's ground one. So I think are we on to the PSED
yes.
next?
Can I,
yes.
Lest I forget, should I just touch on the Let's case that?
Oh yes. Yes, please do.
Yeah. in Letts, this was a case concerning the Lord Chancellor's exceptional funding guidance. As we see,
Yes.
that's the issue. And Mr. Justice Green, as he then was, found that the guidance was unlawful in 3 respects. And we find those at paragraphs 95, 96, and 97.
Yes.
And we then, going on to a 104, paragraph 104, the test to be applied to the legality of guidance. Having concluded there are errors in the guidance, I turn now to the test to be applied to the guidance in light of my conclusions as to the law. So here, I'm faced with guidance that's got mistakes of law in it. What do I do about it? And in paragraph 113, the learned judge says, in my judgment, the guidance is predicated upon the legal errors I've described above. There's a legal error within the body of the guidance itself. And the conclusion as to whether, on the basis of the guidance containing errors of law, he identifies the test at paragraph 118. But, my lords, this is a case about guidance properly made, but containing within it legal errors. And this is not a case where, for example, the public sector equality duty, if it applied, was not given due regard. This is not a case where a consultation, if it was required, was not undertaken. This is a case of what do we do about guidance that's, let's assume it properly made, it's lawful, but it's got mistakes in it, it's got errors of law.
Well, what do you mean properly made? Of course it was
Made lawfully, made lawfully, but contains errors of law. It cannot. This is paragraph 118. Isn't, in my respectful submission, suggesting that a policy or a guidance cannot be quashed if due regard is not given to the public sector equality duty, or if consultation, if required, is not undertaken, or material considerations. If material considerations are ignored, that ought to have been material and ought to have been taken into account, and they haven't been. This is not suggesting that none of that matters, and that you can only quash the guidance in those 3 instances.
But is that what Mr. Justice Green says?
What this case is about a guidance that he has identified as containing within it 3 errors of law. He's not.
What I'm asking you is, where does he make the distinction, if he does, that you're seeking to impress upon us?
He doesn't, but my lord, we must, because otherwise, well, suppose, for example, a local plan. Suppose a planning authority generates a local plan without following the mandatory statutory procedures. Is it to be supposed that that won't be quashed unless one can establish one of the 3 grounds in paragraph 118?
Well, 118 is not, with respect to Mr. Justice Green, it's not particularly innovative. If you look a little way up the page, you've got Lord Justice Richards in Tannack referring back to the House of Lords in Gillick, which was about abortion, wasn't it? It is well established that a policy which, if followed, would lead to unlawful acts or decisions, or which permits or encourages such acts, will itself be unlawful.
Yes, I don't dissent from that, my lord, for a moment. I'm not suggesting that paragraph 118 is wrong in any sense, but what I'm saying is it's not the beginning and the end of the question of when these courts will intervene to quash a guidance or a policy.
So a guidance or policy which was reached without considering some material consideration, but nevertheless did not lead to unlawful acts, did not permit unlawful acts, did not encourage unlawful acts, would nevertheless be quashable.
Yes.
What's your authority for that? The guidance is accurate. The guidance points people in the right direction. It is guidance, but it happens to have omitted mention.
Well, as I say, I go back to the example I gave of a planning authority's local plan. If they just drew up the local plan without any consultation, without any reference to anybody, and then published it, the planning court would have no hesitation in quashing it. And it wouldn't ask these questions.
Those are statutory or regulatory requirements.
Yeah.
Yeah. Yes.
But the requirements of in public law of having due regard to material consideration, the statutory requirement to comply with the public sector equality duty, public law obligation to not frustrate legitimate expectations without good and proportionate reason. Those are equally relevant in terms of assessing whether guidance or policy is lawful and whether it should be allowed to stand or not. They're in addition to what the three tests we find in paragraph 118. So in my submission, it must be the case, my lords, it must be the case that paragraph 18 is dealing with a particular kind of problem with guidance or policy. That's to say, policy or guidance that you can't necessarily challenge on any of the conventional grounds of judicial review, but nonetheless, you find in it there are errors of law. What do you do then? And that's plainly, my lord, that's what Mr. Justice Green, as he then was dealing with in this case. My learned junior has helpfully. Which one is it? Is it joint counsel? Yeah. What paragraph? 7.6. Excuse me. My lord, my learned juniors rightly pointed out that in the JCWI case against the learned senior president.
Sorry. Say that again.
The President of the Upper Tribunal, Immigration and Asylum Chamber.
Yeah. Yeah. Not the senior president.
Not senior president, no. 7.6, my lord. In my judgment, for all these reasons, PGN 16 infringes let's unlawfulness. Actually, that particular type of unlawfulness is attributed to that name by Mr. Justice Fordham. So, in a sense, I suppose, what Mr. Justice Fordham refers to as let's unlawfulness is another branch of unlawfulness. And that's the appropriate way to view it in my respectful submission.
Well, that's his shorthand, isn't it?
Yes.
I don't know whether he uses that shorthand in his book. I haven't looked.
No. But he's talking about what Mr. Justice Green was saying in paragraph 118.
Does he say what he means by let's unlawfulness? It's clearly used there as a term of art.
Yeah.
And so what does he say about that? Is that a question on which you'd like Mr. Streeton to help you?
No, I've got it here, my lord. It's at 7.2.
Yes, well, that reinforces the question.
Mr. Justice Fordham explains what he means, my lord, at paragraph 2.5.
Thank you very much.
Where he cites lets and explains what he means by it.
Thank you very much, Mr. Chair. Yeah.
Yes. Well, that's 2.5 is just a rather good summary, isn't it?
Yes.
Judicial review will lie against a guidance document which either promulgates advice which is erroneous in law, or which is guidance which, if followed, would lead to, and so on.
Yeah. It is in no sense suggesting that the other grounds of challenge have, for some reason, disappeared. This is as it were, a particular type of unlawfulness that, in an appropriate case, will result in guidance or policy being quashed. And I don't have to, in supporting the judge's decision to quash plan and guidance in this case, I don't have to bring, she didn't have to bring the case within the lex unlawfulness category. It was quite sufficient for her to deal with it on the basis of material considerations, public sector equality duty, breach of legitimate expectation, and irrationality.
Yes. All right. Shall we leave Let's and JCWI and let you return to where you were when we do stumps last night, which was to go on to
Public sector equality.
The public sector equality duty.
If you please. I deal first with the plan and the guidance, my lord, and I'll deal obviously with the A10 order separately and afterwards. Can I take my lords to the gather? I'll take my lords to the Gathercole decision of tab 23 that my learned friend referred to in the course of his submission on this topic. Paragraph 23 in the judgment of Lord Justice Coulson. There's a summary of bracking. My lords will be aware that in her judgment, the learned judge set out the public sector equality duty in detail at paragraph 174 and set out a full extract from bracking at paragraph 175 and 176 emphasised that the passage in Bracking was approved by Lord Newburger in Hoppack and Southwark, and set out an extract from that judgment. So there is no question but that the learned judge, who is, of course, an experienced judge of the planning court, had the principles very well in mind. And my learned friend drew your attention in Gathercole to the passage in Gathercole in paragraph 26, the reference to Powell and decorum, where Lord Justice McComb referred back to his judgment in Bracking and emphasised the importance of context. I think my learned friend sought from this to draw some comfort for his submission that in some sense there should be a lesser obligation on a person who was issuing general guidance than on a person who was reaching a narrow decision. But my lords, when one reads the extract from Powell and decorum cited by Lord Justice Coulson at paragraph 26, it's to the opposite effect. Because what Bracking was concerned with was if you will, a macro decision, and a ministerial decision to close a national fund supporting independent living by disabled persons. It wasn't, as it were, a micro decision in respect of one person. And the distinction that Lord Justice Coulson was drawing, or that Lord Justice McComb was drawing in the Powell case, is in the final sentence of that section. The decision of a minister on a matter of national policy will engage very different considerations from that of a local authority official considering whether or not to take any particular step in ongoing proceedings seeking to recover possession of a unit of social housing. That's a micro decision. And of course, it is clear that the considerations that will be engaged in those two are different. But in our submission, the considerations engaged when issuing a policy of wide-ranging application, such as the guidance we've got here and the plan, something which will set the trajectory for future decision-making, and will necessarily be an important material consideration when future decisions on individual, in this case road schemes, are being taken. In those cases,
is this really very different in the present case from ground one? It's a different way of describing the same thing. If you're right that the judge was right to find that the plan and guidance failed to have regard to the material consideration of the special position of taxis, and in particular taxis in providing services to the disabled and elderly, then you succeed on ground one. You probably also succeed on ground two, the public sector equality duty. If they fail to take it into account, then you succeed on ground one and two. But if they didn't fail to take it into account, then you would not succeed on ground one and not succeed on ground two either.
Well, I could, in that hypothetical scenario, my lord, I would not succeed on ground one, but I could still succeed on ground two if they had not taken due regard to the impact on those with protected characteristics.
Right.
That's to say, if they had not complied with their public sector equality duty. And as we say they didn't, and as the judge found they didn't. I think the other case I ought to go to is the Faucet Society, which is at tab 11 in our bundle of authorities. my learned friend sought to rely on this authority for the proposition that actually for the guidance you don't need public sector equality duty. You don't need to concern yourself with public sector equality duty. You just need to draw it to the attention of those people who in the future will be making individual road schemes and tell them that they've got to have due regard to the public sector equality duty. That's enough. And it's that broad proposition that he sought to rely on this. This was a very different case, my lord. If one goes to paragraphs 1 and 2 of the judgment, just as Ousley, the subject matter of the challenge is the 2010 budget in its entirety. It's a claim that really sought to have quashed. And the basis for the challenge is the assertion that Chancellor of the Exchequer failed in various duties under the Sex Discrimination Act 1975. In particular, it's that they failed to, in their duty under Section 76A, to comply with their general duty to have due regard to the need to eliminate unlawful discrimination. At paragraph 8, though, the learned judge found that, in my judgment, it's clear that if the analysis of gender equality impacts can adequately be undertaken by consideration of the line items in the budget, the duty is fulfilled, or rather not breached, by its being dealt with in that way at that stage. For my part, I cannot see any reason why the government is acting unlawfully if that is the way in which it proposes to deal with gender equality issues on the budget. And at paragraph 10, I also accept Mr. Eadie's submission that there are high-level economic judgments as to when and how best to deal with Section 76 issues which arise, whether it's dealt with at the stage of the budget proposals themselves, fixed spending envelopes, or later during the detailed formulation of policy or its implementation. Section 76 permits judgments of that sort to be made in carrying out the duty, and Mr. Eadie's submission in that respect is obviously sound. This was a case where the government had issued the budget as a whole and had made it clear that in respect of the individual line items, it was going to have due regard to its duty under the Act. This is quite different. For one thing, the guidance that we're talking about is not guidance to TfL alone. It's not, as it were, guidance to itself. This is guidance to London as a whole and all local authorities in London as a whole. The duty on TfL under Section 149 of the Public Sector Equality, the Public Sector Equality duty, it must, in the exercise of its functions, have due regard. Now, one of its functions was the issuing of the plan, formulation, publishing of the plan and the guidance. And in that function, it had to have due regard to the various matters identified in Section 149. And it couldn't do that by delegating. It's a non-delegable duty. It couldn't effectively delegate that duty to local authorities. But that's the logic of the argument that my learned friend seeks to raise. He says, oh, well, look, it's all right. TfL could issue the guidance, and as long as they tell other officers in other authorities to discharge the duty under Section 149, that's good enough.
Besides, it may be my fault, but I hadn't understood that really to be the argument. Rather that when you issue general guidance, if the general guidance had said there will be no taxis in any bus lane, then it would have a very direct and obvious effect, and the impact of that would have to be assessed. If the guidance is much more broad, we wish to reduce the amount of motorised traffic, which by implication involves some taxis, but doesn't say the extent, the detail, the critical impact isn't clear. It's a very general principle. Then is not the understanding that you can't really assess the impact on the protected characteristics until you look at the specific way that this guidance will be applied. Isn't that the point?
Well, if that's the point, can I deal with that, my lord? I mean, as I say, this guidance sought to set the trajectory for future decision making by traffic authorities throughout London. And the aim was to encourage the closure of roads to general traffic. And that would, as my lord has rightly said, inevitably impact on taxis and other vehicles relied on by the disabled. And it was important for that impact to be identified if TfL was to, TfL had to have due regard to the impact that its guidance would have.
How are they going to assess it?
What
How could you assess it?
Well, you could. My lord, you can assess the impact of closing roads to those who are disabled and are dependent on motorised transport.
But that may be in the very most general sense. You could say if we close a lot of roads, it'll be more difficult for taxis than those with disabilities who depend on taxis.
Yes.
But that will be the end of it. You then need to say, well, if we close all of the arterial roads inside the central zone, that's going to have a huge impact. If it means one or two routes, when we get down to the detail, that will have much less impact. We need to balance that against the... It's when you get to be granular, horrible word, but you follow what I mean, that you can assess the impact. Here it would it not be just ticking the box or lip service in general terms?
Well,
we recognise if we go too far, it will have an impact on this group.
Or it could be, my lord, deciding that the importance of motorised transport apart from buses to certain disabled and elderly people is such that they ought not to be prevented from using roads.
At all.
Well, that would be part of the consideration. You have due regard to the effect of what you are proposing, what you are advising. Due regard to the effect that it will have on the elderly and the disabled, or is likely to have.
So the TfL and the Mayor had to say, well, we've got to say that in our general guidance, however general that point may be, and remind those who will implement the guidance with specific roads and schemes in mind that they have a public sector equality duty. Is that?
Well, in terms of the plan and the guidance, TfL had itself.
No, I know that. But how would they get beyond saying, if you go too far, this will impact on these groups?
Well, because
Just a minute. In the full knowledge that those who have to implement the guidance in a specific way bear the same duty and will have to make a much more focused assessment of the impact.
Well, had they fulfilled their public sector equality duty in the formulation of the plan and the guidance, then it may well be that the plan and the guidance would have made specific reference to the position of taxis and the disabled. And in fact, it didn't.
But isn't that rather to infantilise the recipients of the guidance? It's guidance to decision makers in boroughs. How much do you have to tell them? We want to get more people. Put the pandemic to one side for a moment. But guidance says we want to get more people on buses. You surely don't have to spell out to borough transport committees or officers. But of course, not everybody can use buses. Double-decker buses are completely useless. The top deck is completely useless to the frail elderly, let alone the disabled. If you pedestrianise a street, then not everybody can walk to the door. I mean, how much of this has to be spelled out? Surely the borough officers would say, but we know all that.
Well, I don't know, my lord. The learned judge found, and in my respectful submission, she was right to find that this was a matter of such importance that it ought to have been and that the public sector equality duty was so important in the context of what the plan and the guidance were setting out to do, that there was no question but that the local authority had to engage with it and have due regard to it, and she found they didn't.
Could I just ask you a question that goes, as it were, to the other end of the whole exercise? It's common ground, I take it, that a public sector equality duty process must be undertaken for the specific scheme in question, whatever it may be, at TfL or borough level. Do you contend that that exercise would be any different, any more expansive or intense, if what you say TfL ought to have done at plan and guidance stage had been done? Or would it be effectively the same exercise?
If TfL, this is going back to the material consideration point, my lord.
Well, it's not. Well, it's connected. All these points are connected, I think. But specifically within the frame of public sector equality duty, it's common ground that the boroughs, or TfL as the case may be, would have to undertake a public sector equality duty exercise, equality impact assessment, whatever it may be, at specific scheme stage.
Yes.
So, for example, with the A10 order or some other traffic restriction order, there would have to be such an exercise. What I'm asking you is whether that exercise would be qualitatively any different if TfL had undertaken what you say they should have undertaken at plan and guidance stage.
Well, it becomes difficult because we say they did not have due regard. Had they had due regard and come to the conclusion that there were real risks involved for the taxis and the disabled in the guidance as originally expressed, and if that had been stated in the guidance, alluded to in the guidance, that could well have had a difference.
Well, of course, but my question is premised on the plan and guidance having been made as they were. You see, that has to be the premise for my question. And I'd like you to focus, please, on the question with that premise in mind. That's to say that the plan and guidance stand as they are, but that a particular scheme comes along. I'm asking you, how would the public sector equality duty have to be differently performed, if at all, at that second stage on that premise?
Well, it wouldn't. But because my point concerns the public sector equality duty at the point of the formulation of the plan and the guidance.
Precisely. And it's because of that I'm asking you the question I am. I'm asking you how the secondary exercise would be any different. I think your answer is that it wouldn't be any different. It would have to be the same exercise in any event, notwithstanding such public sector equality duty exercises had been performed at the first stage.
But my Lord's question was premised on the basis that the plan and the guidance remain precisely the same as they are.
Yes. Well, I'm testing. What I'm doing is testing a specific aspect of your case on the basis of considering what the public sector equality duty would look like, if I can use that expression, at scheme stage. Would it be any different? And I think your answer is it wouldn't be any different.
If they had fulfilled their public sector equality duty at the stage of formulating the plan and the guidance, it is likely that the plan and the guidance would not have been the same as they are, my Lord. That's.
I'm sorry.
If there is a lack of PSED attention or reference in the general guidance, does that relieve the subsequent decision maker thinking about a particular scheme of any obligation in respect of their duty to
No.
consider.
No, Molly. No, but I am concerned that we are, as it were, moving the goalposts from my challenge. What I'm dealing with at this point is a challenge to the plan and the guidance, and my submission, my respectful submission, and as found by the learned judge, is that TfL fell into error in not complying with their public sector equality duty at that point.
Mr. Mathias, we understand your argument. What we're doing is testing it. And my Lord has actually articulated the question in a much more approachable and specific way than I managed.
Lord, may I turn my back on the court for one moment? The importance of the plan and the guidance is that it sets the trajectory for all future decision making.
Of course.
And if the plan and the guidance remain the same, that's to say taking no account of taxis and the impact on taxis, no account on the disabled, well, that's a countervailing point to any decision made by a local authority, a local planning authority.
Well, I'm sorry, I simply don't understand that submission.
The way in which the learned judge summarised the position is to be found at paragraph 186 in her judgment. What she was talking about there is if we, in the core bundle, at tab 18, page 430. Yeah, 430 in the core bundle. So this is what is in the guidance regarding questions of qualities. And it does repay rereading. Bottom of page 430. It's therefore an essential part of protecting vulnerable Londoners. Providing additional space for walking and cycling will help support those who are less mobile and those who may be new to cycling. So that's essentially merely asserting the benefits of the plan. Essentially saying the plan is going to be all to the good.
Well, we've been through 430 and 431, and you say this is pretty flimsy. But the judge's criticism seemed to me to go way beyond the document doesn't spell these things out. She refers to Lord Justice McComb's judgment in Bracking and said that a full conscientious assessment of all the equality aspects should have been made before the plan and guidance were promulgated.
Yeah.
How long would that have taken?
it would have required would have required an understanding and analysis of the extent to which road closures adversely impact on those unable to walk any distance and entirely dependent on motorised transport to get from door to door. And the effect on those persons, due regard would have to be had to the effect of these proposals on those persons. Reading the paragraphs 430 and 431, which is why I said they do replace some additional consideration, it seems to be to the opposite effect, that the guidance and the proposal for bus and cycle pedestrian-only ways will work to the advantage of those. You see at the top of page 431, walking is one of the easiest forms of physical activity, suitable for Londoners of all ages and abilities. Our plans, which provide space for people to exercise in areas where there's less access to public or private outdoor spaces, are an important part of supporting the health and well-being of the most vulnerable.
Well, it also says, when making any changes to street layouts, boroughs are asked to use existing guidance to ensure these changes don't detract from current accessibility levels.
Yes.
Well, what does that mean?
That's as close as they get to saying anything about the adverse impact of this guidance.
Saying both sides of it, that it makes it easier for some people who've got limited mobility, but watch out that existing accessibility levels aren't detracted unless you have to, and enhance them where possible. And farther down the page, ensure that all impacts on protected characteristics will be considered at every stage. Anticipate the consequences on these groups.
But you will see the last sentence in that paragraph, my lord. The creation of an inclusive environment is one of the key design considerations of the project. It is expected the overall effect on equality target groups will be positive.
But we're back to what I was saying earlier, Mr. Mathias. I mean, that's such generalisation, necessarily. But what this is really, if you read this intelligently, you're saying you've got things going both ways. You've got to have a regard to the protected characteristics of all kinds. There are many others one could look at. And bear it in mind when you're thinking about a specific scheme. Does it get beyond that? How could it get beyond that?
Well, my lord, at risk of repeating myself, they could have engaged with the difficulties that will be caused to those who cannot walk if roads are closed to motorised transport, and they might have considered how those difficulties can be ameliorated, and they might then have decided to put something in their guidance to that effect. The risk is that transport officers reading this will focus on the fact that there is no mention of the problems that this guidance, this plan will cause to the disabled, and the difficulty that it will cause to taxis, and will read the section we've read, and that will, as it were, as I've said, set trajectory for their thinking in devising individual schemes. Because as general regard to issues of equality, and this is the most general regard possible. General regard to issues of equality is not the same as having specific regard, by way of a conscientious approach to the statutory criteria, as Mr. Justice Davis said in the Meany case, which is cited by the learned judge.
So do you want us to look at Meany, or is it adequately cited by the judge?
It's
Where does she refer to it?
I think it's in bracking. It's Principle 6. If one goes to her judgment, paragraph 175, And it's the sixth principle, if you will, that's cited by Lord Justice McComb in Brackey. General regard to issues of equality is not the same as having specific regard by way of conscientious approach to the statutory criteria.
Yes, well, that seems an unexceptionable and unsurprising principle.
Yes, and that's all. Putting this at its highest, putting this at its very highest, what is set out on in the guidance at pages 430 and 431. If it's any regard at all, it's the most general regard, and that is why the learned judge, we would say quite rightly, found that at paragraph 186 of the judgment, if this was indeed intended to be a discharge of the public sector quality duty, it fell far short of the detailed and conscientious scrutiny which was required. It amounted to a mere justification of the decision already taken. And I invite my lords to read on to the end of that paragraph, which is my submission very important to an understanding of why the learned judge came to the decision he did on this point.
Well, if she is right, as I said a few minutes ago, it's not just a question of the document not dealing with this in sufficient detail, it's that they should have carried out a full, rigorous, detailed equality impact assessment before issuing any guidance to anyone.
Yes, certainly guidance that was going to have such a dramatic impact on those with disabilities.
Is there any reference anywhere in the judgment to the emergency nature of the situation as it was at the 15th of May 2020?
Yes. Well, I think we find I'm not saying this is the only reference, my lord, but if one goes to paragraph 218 of that judgment, this is the legitimate expectation ground. In response, the defendant submitted the claimants had not identified any clear, unambiguous statement upon which a legitimate expectation could be founded. Even if there were such a legitimate expectation, an emergency measure in response to a pandemic was a paradigm example of a case.
Well, that was the defendant's submission. But
Yeah.
What does the judge say about it?
I don't want to interrupt my learned friend, but the most detailed analysis the judge provides of the emergency situation is under the heading of rationality from 265 onwards.
Thank you.
Where the judge asks herself the question of whether the outcome was a rational response to the transport issues arising as a result of the pandemic, which I think must include.
Well, 266 we,
Thank you.
of course, we've looked at, but
I mean, in fact, at 269, much of the thrust of that is that it wasn't actually such an emergency because people were staying at home.
And the source of evidence for that proposition?
Which one, my lord, the staying at home?
Well, that which must have been apparent to the mayor and TfL. And then the judge says that people were responding to the pandemic by staying at home, especially office workers.
It's the evidence of Miss Karen Proctor, which is in the supplementary appeal bundle, my lord, at page 133.
Right.
I don't know whether this is summarised anywhere in the evidence, but we all recall that in the very early stages, following the enactment of the Coronavirus Act and regulations, it was illegal to leave your home except for certain specified reasons. The streets of London were deserted, and that continued for a while. I can't remember whether that was still the position as at the 15th of May.
Oh, it was. I don't know if we're talking about personal experiences. I can remember being in the city during the summer of July, I think, and it was like being there on a weekday. It was like being there on a Sunday.
Yeah.
Because the office, well, this is the and actually this is the evidence Ms. Proctor gives at 133.
Right.
It's paragraph 46.
Yeah. But anyhow, I was asking this in the context of the Bracking assessment, and the defendants say at the time that we issued the guidance, the nation was 6 or 7 weeks into lockdown. Nobody had any idea how long this would last, whether there would ever be a vaccine, whether we'd have to social distance forever or just for a few weeks. The government was introducing restrictions for 3 weeks at a time and then 6 weeks at a time and so on. We had to give interim guidance to boroughs as to what they should do next. And that's the context in which we issued the guidance on the 15th of May. The judge's criticisms seem rather harsh. No doubt in time of peace, as it were, all sorts of studies might have been undertaken. And if there is ever to be, after the pandemic is over, if there's ever to be an enormous restriction on the use of vehicular traffic in central London, all sorts of public law considerations would come into play. But the judge doesn't seem to have given the defendants any sort of slack in the need to act quickly in response to an unparalleled and unpredictable situation. All right, you didn't have the Lord Chief Justice's judgment in Dolan. That only came later, but all this was rather obvious, wasn't it?
Well, the Dolan judgment, my lord, is a very different matter to this. The thrust of the concerns expressed by the learned judge in her judgment about plan and the guidance was the disregard in those documents of the disabled and the taxi trade, in short. The disregard. Now, there was the and
No, well, that's point one.
that's
But
what
point two, I was focusing on her recital of Lord Justice McCabe's judgment in Bracking and saying that there wasn't the rigorous assessment with an open mind and all that, which at points 6, 7, and 8, or whatever it is, of Bracking.
in fairness, that wouldn't take long. That would take a few days, perhaps at most. But it just wasn't done. There was no attempt made to rigorously and conscientiously consider the matter. And I think my Lord Stephen, my Lord Sir Stephen Irwin, my Lord, you put your finger on it. I think that as far as they were concerned, it could all be left to those who are making the traffic orders.
No, I'm saying that the detailed impact could only really be made when you look at specifics. That's the point I was making. Otherwise, one is dealing with not just as my Lord has said, a hugely unpredictable general situation over the summer of 2020, but assessing the impact could only be done at the most general level until you look at the specific road closure.
But you could give conscientious consideration, albeit in general terms. Then that's what they failed to do. They didn't. There was no conscientious attempt to consider, well, what impact are these recommendations, this trajectory we're setting, what impact is this going to have on those who are dependent upon motorised transport in order to get about at all?
Well, your point would be met in its entirety, it seems to me, if there'd been two sentences saying, do bear in mind that there are people who need to use motorised transport, and that is something you will need to consider when you come to look at specific schemes under the PSE duties that you will owe. That's it. Am I right? Is there anything more that you could require them to say?
You could, well, my Lord, yes, you'd emphasise the importance of taxis to those to
single out taxis.
Taxis because they are wheelchair accessible. They're fully accessible to all disabled persons. Mm-hmm. Those are matters that would have come to their attention had they engaged in the public sector equality duty at the stage of making the plan and the guidance. The importance of those matters they would have become aware of them.
Well, we get to 3 sentences then, do we? I mean, I'm not being frivolous. It just seems to me that the weakness in the proposition you're advancing in seeking to support a finding that there was no consideration given in the face of the text we've read is that you need to add to the text we've read some reference to taxis, some reference to those who can't walk.
All the Act says, of course, is you have to pay due regard.
No, I'm asking you to be crisp as to what you say more was required. And I can't, for the life of me, imagine what else you could be requiring. And I question how much difference that would make.
Well, if the guidance had contained
some reference to taxis, and some reference to the use of taxis by people
and their importance, and the discriminatory effect of road closures on those with disabilities and the elderly who can't use can't walk or cycle. If there had been references of that kind that would have emerged from a discharge of the public sector equality duty, then the guidance wouldn't be challenged on round 1 or round 2, of course.
So all Londoners, see page 431, to move around in safety.
Yeah.
And then
Sorry, where is my Lord?
at the top of page 431.
Yes.
And then lower down after the setting out of section 149
Yeah.
and section 17 of the Crime and Disorder Act.
Yes.
reference to officers considering all impacts on protected characteristics to be considered at every stage of the programme. And all Londoners clearly does include taxi users who have disabilities, doesn't it? All impacts on protected characteristics would encompass that same cohort, including those who are obliged to use taxis because no other mode of transport caters properly for their needs. Are they not encompassed? You may very well say they're not spelt out as a specific cohort, but are they not encompassed within the scope of that exercise?
Well, my lord, we simply say they should have said so.
No, that's not quite an answer to my question, which is a simple question of fact. Is that cohort not included within those formulations, all Londoners moving around in safety, and all impacts on protected characteristics? That's the question.
Well, it's it's the generality of it that we take exception with.
I know, hence my question.
I don't know, my lord. I don't know what the author of this document meant to encompass by that, and frankly, a person reading it wouldn't know. He might suppose it included taxis and the disabled. He might not.
Just to emphasise, the reader, if the reader does her job properly, will start at the top of the page by saying, make sure that your schemes don't detract from current accessibility levels and enhance them where possible. We'll then read part 3 of the Equality Act gives disabled people the right of access to goods, facilities, services and premises, and points out it's unlawful for service providers, but it gives the broader right of accessibility, and then emphasises that all impacts on protected characteristics which will be considered at every stage of the programme. Protected characteristics as a matter of law, as well as common sense, include those with restricted mobility. So to the answer to my Lord's question has to be yes. So the fair reading involves current accessibility levels, not to be detracted from, enhance them where possible, disabled people have a right of access to premises, and please look at all protected characteristics and impacts. Now, all you could possibly add is the word taxis in some sentence that refers to the use of taxis by those with disability problems. That's all, realistically. Do you agree?
Well, my lord, I have to maintain the position that was expressed so clearly by the learned judge, that they did not have due regard in the formulation of this guidance to the public sector equality. They set it out, they summarised section 149 in the section that my lord has referred to. They told officers to ensure all impacts on protected characteristics, they say, will be considered at every stage, although they weren't considered at this stage. And then they go on to, they end up by saying the creation of an inclusive environment, it is expected the overall effect on equality target groups will be positive. It's just difficult to understand how that expression of hope, I suppose, can be...
Well, it's more than hope. It's more than hope. It's expectation, and indeed, it's an aspiration. It's an aspiration to ensure, as Mr. Jaffe was submitting, that on balance, yes, it is an invidious and difficult balance, but on balance, the overall effect on equality target groups will be positive, i.e. for the better.
Well,
I mean, that's what they're saying. You may disagree. Many people may disagree, but that is what the policy document states as its expectation.
Mm. And there, I suppose, my lord, there's the real mischief, because it's an expectation. It, as I say, setting a trajectory, follow this guidance, and the outcome on the equality target groups will be positive. But of course, it won't be positive on those who can't walk or cycle under dependent on.
Of course not. Of course not. But why does that make it unlawful?
Well, the illegality, I won't labour this point, Muller, the illegality lies in the fact that they did not engage in a conscientious consideration of that at this stage. They essentially seem to be saying, look, I fear I'm repeating myself.
I think we've probably done the PSED to death.
One more question.
Right.
One more question.
Yes.
Can we go back to paragraph 186 of the judgment? It's
Yes,
page 120. These are the judge's conclusions on this. There's a sentence which begins, if this was indeed, I'm sorry.
Yes, I'm there.
If this was indeed intended to be a discharge of public sector equality, you fell far short of detailed conscientious scrutiny which was required. Now that clearly was your main submission.
Yeah.
He goes on to say it amounted to a mere justification of the decision already taken.
Yeah.
Did you ask her to infer that?
Check with my learned Juno.
Yes.
I can check it. I can't.
Don't
remember.
take time over it now.
No,
it would be helpful to know if you made a specific submission that this was, in essence, a fig leaf for a predetermined.
I cannot remember whether I did or not.
No.
I would be quite comfortable to have made that submission, because in my respectful submission, one has only to read the first paragraph on page 431. Oh, you read the last paragraph on page 430, my lord. The first paragraph on page 431.
For the moment, I'm not asking you to justify
No.
your submission. I simply want to.
No, I thought I might just explain to my lord why I could well have made that submission, and it's a submission I would adopt, and I would respectfully say that a fair reading of this, and you see it in bottom of page 430, is therefore an essential part of protecting. It's an essential part of protecting vulnerable Londoners. Providing additional space for walking and cycling will help support those who are less mobile and those who may be new to cycling. And then at the top of the next page, walking is one of the easiest forms of physical activity which is suitable for Londoners of all ages and abilities.
I know what it says.
Yes.
The question is simpler than that. I'd
Did
simply like to know. Take your
How
time.
did you put it to the judge?
Yes.
I've just been looking at the claimant scalloped argument below, helpfully included at tab 10. And under the equality impact assessment, you and Mr. Streeton start with the law, paragraphs 72, page 224, set out the law, section 149, bracking, approved in HOTAC and so on. And then you move on to the facts at 76 to 81, and you say that the defendants accept no equality impact assessment was conducted prior to disseminating the plan. The facts of this case illustrate, 78, the facts illustrate the dangers of not conscientiously addressing the statutory criteria prior to the adoption of policy. 79, no evidence whatsoever to show that defendants considered the adverse impact themselves. All of which you have said to us this morning. And 81, the defendants did not conscientiously address the statutory criteria before making a decision. But it's nowhere said there that what is put at pages 430 and 431 is a fig leaf to cover a predetermined decision.
Sorry.
So,
83 is
paragraph 83 on the A10 order, that submission is made, but not in relation to the guidance of the plan.
It is made in relation to the A10 order, but not on the main claim.
Yeah.
I think it might be said expressio unius rule applies. Anyway,
Well,
the judge.
yes, and also, of course, I could well have said it orally. With my respect, in my respectful submission, it's the correct position.
All right. Now, time marches on. Are we done with the PSED?
Well, we're done with it so far as the plan and the guidance are
yes,
concerned, my lord.
yes.
And unless
Then we have legitimate expectation, plan and guidance, and then you go on to the A10 order.
can I deal with the?
You want to deal with
the A10 order first, my lord, in terms
you like,
of
yes.
quality views? I'd rather do
All
that.
right.
So, can I ask my lord to take up the document containing the equalities impact assessment, please? And my learned friend Mr. Jaffe produced an enlarged version in A3, and we have produced in A1. There's the page that we produce in A1, the page with the chart, as it were. But
you want us to have a look at the...
before coming to the... Yes, I'd like to come to that, my lord, but before coming to that, it's important to go to page 535, which shows the colour coding that is used in the chart, so that one has an understanding of that. So that's that. That's the colour coding. It might be.
R35 is the quality impact assessment.
Ah, this is the version that Mr. Jaffe gave me yesterday. This is his enlarged version, which has it the colour.
535 is a single sheet saying what the colours mean.
Yes, that's right. Yes.
Good.
So it's they're talking about the residual risk. Risks assessed once the change, impact and mitigation sections are complete and agreed. The risk will be assessed by the D&I, diversity and inclusivity, in conjunction with the team. Definitions are outlined below. And red, this an impact will have a significant effect on the identified groups of people. This may create a barrier that prevents someone from completing their journey. There may also be an impact on mental health and well-being. This could result in discrimination due to the disproportionate impact on identified groups. That's red. And then there's amber, likely to have a negative effect on the identified groups, although it's unlikely to prevent access or completion of the journey. Likely to result in greater inconvenience when measured against someone who does not have the same protected characteristics. This may result in discrimination. And then there's blue. We don't need to consider blue because that doesn't arise in our case. But green, either no negative impacts have been identified or mitigations will ensure that people are not put at greater inconvenience to someone who does not have the protected characteristic. So that's the colour coding. And I'd respectfully submit that that is important because a decision maker considering a proposed decision and being confronted with an equalities impact assessment is likely to use that colour coding as a ready reference to the severity of impacts. Now, if I could...
It doesn't mean you ignore the text, does it? It's a broad indication of the nature of the impact. So you have to read it together with the text that goes alongside it.
Just so, my lord. Just so. And but red would, if you were a decision maker, a red mark would make you think, oh well, maybe there's something we ought to be altering here.
Yes, but even the language that goes with red is conditional.
Yes.
May create, may also be, could result.
Yes. 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 So if one goes to the chart now, please.
The big one.
The big, if you please, my lord. And I think there's the coding at the top. So the left-hand column is the proposed change that's being addressed. Then the impact on those with protected characteristics, obviously, is identified either as negative or positive in the next column. Then the impacts are numbered. And then the impact for customers is identified. Then the evidence in respect of the impact is identified. Then mitigations and recommendations are in the next column. Then we've got 3 columns which indicate whether the mitigation's been implemented or not. And then an explanation of the implementation. And then we've got the colour coding, what they call the residual risk. Now, if one looks at, firstly, please, impact 7. Now, what impact 7? This is the A10 order, of course. What this is concerned with is the fact, in the left-hand column, the scheme proposes removing through traffic from the corridor from 7 a.m. to 7 p.m. Monday to Friday, introducing a number of bus gates and band turns. Taxis, private hire vehicles, and those who need to service properties or require any other type of access along the corridor will continue to be able to access the majority of the corridor, with the exception of 2 stretches that are bus and cycle only between the hours of operation, but may need to use alternative routes to do so depending on their origin and destination around the corridor. Now, that's regarded as having a negative impact, and then the impact is defined in the next large column, identifying that these 2 sections between Middlesex Street and Liverpool Street and between Leadenhall Street and Fenchurch Street, it'll now be necessary to walk up to 85 and 90 metres respectively, because they're 170 metres and 180 metres long. Of course, that incidentally, my lords, that's assuming you are dropped at the right end of the exclusion zone, as it were. And there was evidence about this. It's very difficult for a taxi driver to get to what is necessarily the optimum end of the exclusion order, the exclusion section. So you've got an exclusion section of 180 metres. It could well be that the taxi driver, with the best will in the world, ends up at the wrong end of the exclusion zone for the address that his passenger wants to go to. ending up with the passenger having to walk 120 or 130 metres. But that it's important to bear that in mind.
One can draw upon general experience, perhaps, here, I don't know, but the taxi driver may ask the fare, which end of such and such a stretch of street is it? And the answer may be, oh, at the top end, or the answer may be, oh, I'm not sure.
Yes.
Over time, presumably taxi drivers become familiar with particular locations.
Yeah.
But I mean, that's an evidential refinement that perhaps the court shouldn't indulge in.
No. There is evidence about this in the witness statement of Richard Massett.
This is Mr. Massett, yes, and it costs a lot more.
Yes.
And you could, as the mitigation column says, you can. There will still be a taxi rank at Liverpool Street Station, but it's the other side of Liverpool Street Station, and I think we were told yesterday about Primrose Street is one corner of Liverpool Street location where there's special disabled access, but
Yes, which is now very difficult to get to.
it's difficult to get to. So, yes.
And
Right.
yes, and coming out of Liverpool Street Station now on that taxi rank question, you can't turn north. So that if somebody wanting to come out of Liverpool, they get into a taxi, they want to go up to Shoreditch to their hotel perhaps, and the taxi has to go in a southerly direction and take a very circuitous route
Yes.
to get them. It's the and this is a detail that the learned judge went into in some considerable detail, and there's quite considerable evidence about it. And a lot of the evidence isn't before you, my lords, because it was exhibited to the witness statements, and all of that evidence is not before you. But
Yes.
The effect of these closures makes life exceedingly difficult for taxi drivers, to put it mildly. And I only mention that here because this reference to 85 and 90 metres, one mustn't go away with the impression that that's all it will involve. Sometimes it will involve the passenger having to walk further if they're able to get to the premises that are their destination. So
Yes.
it goes on. These sections result from the location of the bus gate signage and band turns. This may have an impact on people who are unable to walk these distances but require access, which is, shall I say, putting it mildly. Because somebody unable to walk these distances, quite simply, won't be able to get there. It necessarily follows. What they're saying is there will be people who just can't get to their destination.
Well, I mean, may have an impact on people who are unable to walk. Would include wheelchair users.
Yes.
You complain about the verb may. Do you?
Well, may. Yes, may.
You say it really should have been will.
It will.
Because whether it be a big impact or a small one, depending on the nature of the person's disability or mobility,
It will.
it will. You say,
Of course.
and so it should properly have said will rather than may. You submit.
Yes. Yes. Because it will prevent certain persons completing their journey.
Well, it doesn't necessarily mean that. That's my Lord's point. It will have an impact. It's not the same as they won't be able to get there. It depends whether they've got a wheelchair or crutches, whether they can with 2 sticks get there or not.
Exactly. For some people, it will just make life very difficult.
Difficult for some.
For some, it will prevent them completing their journey. Yes, I will, absolutely. So, going next to the evidence to substantiate this.
Well, this is dealt with in some detail by the judge of 189, 190, 191, 192, 193, 194.
Yes.
Can we not take those as face value?
Well, my lord, yes, because but they lead to the conclusion. And
They seem to lead to the conclusion the only possible lawful decision was to leave things just as they were as regards taxes, at least.
well, not exactly, my lord. Not exactly. There were other options that were available had they put their mind to it. They could, for example, have excluded taxis during peak hours. They could, for example, have given certain access to taxis carrying disabled people. There were other approaches they might have taken. But
Were these points, forgive me for cutting into what you're saying, were these points made by the LTDA or not? The points you're now making?
what the only point yes, yes,
They were made to TfL, the suggestions. Well, look, if you're going to do this, can you make it the least possible restriction and confine it to peak hours?
I think what my lord has to bear in mind, that wasn't specifically mentioned. However, bear in mind, my lord, that the LTDA and the United Trade Action Group, whom I represent, and the taxi trade as a whole, were not even notified of this scheme until the day before it was due to be advertised.
Well, yes. Then there was, unlike the plan and guidance, there was a helpful exchange of letters, wasn't there? I mean, we were shown yesterday, but I can't remember.
Well, I can take you to it now, my lord. It's
the LTDA letter.
yes, I can certainly take you to it.
Page 500 are the representations dealing with accessibility.
Well, what I was going to do first, my lord, I think it's important first to go to the meeting on the 2nd of July.
Yes.
And that's, bear with me one moment, my lord.
Is that 470?
Yes, that's right. SM, we see a point 3. This is taxi trade meeting on the 2nd of July. SM, that's Mr. Monk, gave an introduction about the Street Space for London programme, emphasised public health imperative, safe restart of the economy and enabling public transport to operate with a much reduced capacity. Emphasis for TfL and the 33 boroughs is facilitating and encouraging more walking and cycling by providing more space and reassurance over safety. The role taxis play is recognised and has been carefully considered in our deliberations, he says. But there's no mention of the bus lane policy. And then he turns to Bishopsgate. He detailed proposals and regretted that they'd not been able to share them earlier. Well, my lord, that was entirely TfL's choice not to share them earlier. They described the point closures and bus and cycle only gates. And my lord, having seen the map, you'll appreciate just how complicated the scheme is. And frankly, without maps, you can't understand it. So the description, Bishopsgate, a highly pressured corridor with pre-COVID huge challenges for pedestrians and cyclists and bus operations. The measures are designed to prevent through movement along corridor. And then curiously says other than bus/taxi. But they've been designed to allow access to destinations along Bishopsgate via side roads. We've also ensured access to Liverpool Street Station, ranking maintained. The measures have been designed together with City of London plans to ensure network compatibility. And then he says, despite concerns about the press coverage, we're not seeking to exclude taxi access in central London. And Mr. McNamara, who is the chairman of the LTDA, then at point 5 says, well, he doesn't understand the plans. and Miss Proctor at 6, identifies that the key issue is a lack of effective communication as to what is actually happening. So, in my submission, one's got to be very careful about any criticism or comment on those whom I represent for not making representation. The first they knew of it was on the 2nd of July.
Yes, but then they write a
write the
perfectly coherent and sensible letter, if I may say so, at 498 following.
479, I think, my lord.
Yeah.
In twice.
Oh, it's in twice.
Maybe the same thing.
Okay. Oh, I see. Yes, because it's yes.
Yes.
So,
And
my lords can read the letter.
yes, well, we did yesterday, and it says that taxis should be allowed direct access for necessary passengers. And,
Yes.
And it gives all sorts of reasons for that.
Yes.
There weren't alternative suggestions of what about special provision for particular vehicles owned by disabled people, or particular subspecies of taxis, and what about reducing the hours during which the taxis are prevented from being there. That's not a criticism. They made their representations on the 14th of July. The order was made nevertheless.
Yes. Yes. I mean, my lord might conclude they did rather well in the very limited time they were given to respond.
I agree.
And there was no response to that letter until after the decision had been made. And
But it's not suggested the letter wasn't taken into account, is it?
this letter was before the decision maker, and there's no question that it was there, and it was addressed in brief terms on page 488.
Yeah.
But
so it was demonstrably taken into account, wasn't it?
yes, yes. But when this is the letter to the decision, the request for the decision letter. This is the letter beginning at page 485. And if one reads, I think the relevant part, so far as the letter we're looking at now, from the LTDA is concerned, is on page 488 and over to the beginning of 489. And you see that the effect of this letter to the decision maker is to discount the concerns that had been raised by the LTDA. We see in that final paragraph, it's considered that the project already takes into account concerns raised by both the LTDA and the LCDC. That's the another taxi driver group. This is reflected in the design of the proposals and the equalities considerations pursuant to TfL's obligations under the Equality Act 2010, as set out in the appended Equality Impact Assessment. So that the
Well, that's not to be read as suggesting that the author of this document thought that all of the things that the LTDA had asked for were being implemented. It is to refer to the concerns raised, which were the in-principle concerns articulated very clearly, if I may say so, in the representations made.
yes,
They'd had regard to the concerns. They didn't ultimately accept the particular measures advocated.
no,
Such as they were.
no. What you do not find from this document is any reference to the bus lane policy or any attempt to engage with the bus lane policy.
Well, that's a separate point again. But,
No. No, I think but it is important, my lord, just to appreciate the limitations of this in terms of the challenge that we are making.
Well, the bus lane policy, we've been round a few times, but it's common ground, as I understand it, that the bus lane policy is not an absolute policy, it's a qualified policy.
That's right. That's why it's so important to engage with it, so as to identify whether this case is an appropriate exception.
Well, this case, whether the circumstances of this case provide an operational reason for doing what the order did.
Yes.
Mr. Mathias, I've seen a document at page 506, which I don't think you've taken us to. I think must be an internal document, or at least not served on your side. You can see in the middle of the text, it's from Mr. Monk.
Yes.
The bottom line, from Mr. Monk to a series of addressees. And in the middle it says, overall, our view is that the design of the project has struck the right balance, taking into account access needs that are catered to by the taxi trade.
Yeah. This is I apprehend, my lord, this is the email. The document we looked at 485, the request for the decision, is dated, as I understand it, the 14th of July.
Yeah.
And it is likely, I suspect, that this email that my lord's just drawn my attention to, dated the 15th of July, was either the covering email under which this request for decision was sent, or is sent with regard to that.
Looks like it, doesn't it?
Yes.
We were told that page 485 was 14th of July, request for decision, and then 506, 15th of July, 10:38 a.m. We're bringing this decision for you, to you for consistency, given that you took
Yes,
the
it is.
decision.
Yes, it is.
This report is updated. This report is presumably page 485.
Yeah, and it's updated. It's updated. There was a previous version on the 1st of July, which is at tab 44.
No.
And what they've done is update it to take account of essentially the representation from the LTDA.
Yes.
Right. Thank you.
Anyhow, the judge found that the A10 order went far beyond what was reasonably required to meet the temporary challenges.
Yes, and it is important if my lords have concerns about the accuracy of that finding. That's why it is important that I take you to the detail of the chart, which I can do fairly quickly, but I don't know whether if this is a convenient moment. I can do that very shortly afterwards.
Well, perhaps we could put this issue to bed now.
Well, happy to do that, my lord. Happy to do that. So, line 7. And the column headed Mitigations and Recommendations. There's a reference to maintaining access to the taxi rank at Liverpool Street Station, which is nothing to the point of with regard to the concern that is evinced in the first column.
Sorry, why is it nothing to the point?
Because the concern was the removal of through traffic and the effect of the bus gates. Mm-hmm. And the impact is in the next large column, the two sections of the road that are blocked off from traffic, and the difficulty that people will have accessing premises within those restricted areas. It's not about, on the face of it, it's not about Liverpool Street anyway. taxi access is maintained at Liverpool Street Station, but that isn't a mitigation to the problem that has been identified. That was a simple point I made, my lord. And then the next section, which you'll see, alternative branches of certain retail units, found in Bishopsgate, are available nearby for those who require door-to-door access. Those properties only accessible from Bishopsgate would become more difficult to access by car, taxi, private hire vehicle, or van. Again, that's a gross understatement. Wouldn't not become more difficult for people? They would become impossible for some. And yet, in the mitigation implementation columns, it's identified as a partial mitigation. And it's difficult to see what the partial mitigation is. Again, in the implementation explanation column, they again make reference to the taxi rank at Liverpool Street Station. Conversely, for those accessing the area by foot, cycle or bus, it's expected for access to be easier as a result of the reduced traffic levels as a consequence of the scheme. But what about the adverse effect on those who are unable to walk? Which is what this is supposed to be concerned about. And then the residual risk, which on any view of the matter, in my respectful submission, if we understand the colour coding correctly, ought to have been red, but this is shown as amber. Remembering, my lords, that red is the colour coding for something that may create a barrier that prevents someone from completing their journey. That's exactly what this is. Whereas amber is something that is unlikely to prevent access or completion of the journey.
Yeah.
And that, of course, is what the learned judge found. This is the colour coding here is quite wrong.
And therefore?
Therefore, when the decision maker came to consider the equalities impact assessment, because it was copied, it was put before him, and looked at it to see, well, I'm going to go, my lord, to what he was told about it. That's important. But also, if he looked at it, let's assume he looked at it, he would have looked for any red impacts, because red impacts would have been the most important impacts. Red impacts are impacts that might have caused him to say, well, now I think there's an aspect here we ought to look at again. But there were no red impacts, but there should have been. There should have been red impacts on impact. There should have been red coding on impact 7, as I've said. 11 was identified in 2 parts, one as green, one as amber. 13 was identified as amber, should have been red. 15 identified as amber, should have been red. Those are all impacts that would have had the effect of preventing some persons with disabilities from completing their journey.
Yes. This attractive chart has to be read along with the request for decision document, which we were looking at. And that we looked at page 488 yesterday.
Yes, and it's important to see what it says about it, my lord. It's on page 489.
Yes.
TfL, it says, has complied with its public sector equality duty, and then that's described. They then say, an equality impact assessment has been undertaken on the scheme proposal. This is provided for consideration by the decision maker. This acknowledges that there will be some negative impacts on members of the public with certain protected characteristics arising from changes to bus stop locations, certain bus stopping locations, and localised access changes. And I don't need to read it all out, but the final sentence is important. Overall, it's felt the positive impacts in terms of new pedestrian space and improvements to conditions for cyclists and bus users as a response to the public health imperatives warrant continuing with the scheme as designed. So there's no attempt to identify the specific problems that I've referred to at 7, 11, 13 and 15. Yeah. And anyone looking at the Equalities Impact Assessment would fairly conclude that none of those are matters that prevented people with protected characteristics from completing their journeys.
Which cohort precisely are we dealing with here?
Of persons, one would be talking about elderly people.
Well, how do you? Sorry, I don't mean you to enumerate them. I mean you to identify what the relevant cohort is.
In terms of the Act, my lord.
Yeah. Well, yes. Or if you want to expand on what the statute provides, by all means do so. But what is the cohort with protected characteristics that we are dealing with here?
The disabled and the elderly.
Right. Yeah. And is the correct approach in such an assessment as this to consider whether there might be one or two or three or a certain number of people within that cohort, or is it to look at the cohort as a whole? Who suffer the impact in question?
Well, I think one takes the assessment on its own terms, my lord.
I'm sorry, that's not quite confronting my question, Mr. Mathias. Is the proper approach to ask oneself whether there might be one or a certain number of members of that cohort who are affected in a particular way, or is it to look at the cohort as a whole?
One has to look at any individuals within the cohort. I mean, it's a huge cohort. The disabled, they're not all disabled people, will be disadvantaged by restrictions such as, but there are some who will.
So is it your contention that if there's one person with a disability who suffers an impact of the kind described in colour coding red, then the colour coding red has to be applied to that particular impact?
That's the way, that is the approach, yes. Because red indicates this may create a barrier that prevents someone from completing their journey. That's what red means.
Yeah, well, yes, someone, yes.
Yes.
But your contention is that if there's any single individual affected in that way, the colour coding must be red.
Must be red. Now, so due regard must be had to that.
But that's the error here, is it? That it should have been red. Should have been red.
There are numerous errors in this document.
No, please, Mr. Mathias, just focus on the question. The error here, for which you contend, is that because there is at least one person who will suffer, or is likely to suffer, the impact as described in colour coding red, the colour coding red should have been applied in the chart. Is that the submission?
No, my lord, no. The submission is reading the chart as a whole. It's talking about, it's not identifying one person, it's talking about people. So if you look in column in line 7, we saw that last sentence.
Well, let me put the question to you in a slightly different way, or expanded way. If there are some people in the relevant cohort who are benefited by the scheme and others who are disadvantaged, is it permissible in undertaking this exercise to strike a balance of judgment?
Not in the colour coding.
It's not.
No. That would be subsequently. You would then decide. Well, look, in the light of the prejudice that some people will suffer, we will consider that against what we perceive to be the benefits that others will. But you've got to identify.
Wouldn't that end up with every scheme for pedestrianising any road, restricting any form of traffic, even private cars, to deliver people to the door, would always have to be colour-coded red. There will be some people, the elderly, the disabled, who would be seriously hampered in their wish to get to a particular spot on Bishopsgate, say, or any other road by any such proposal. That's sort of obvious, isn't it? But you're saying that that means that there must always be colour coding of red. Suppose you're right. So what? Why is the decision to be impugned, as the judge found, not only failure to have due regard to the public sector quality duty, but it's irrational because it goes far beyond what's necessary. Why was that a judgment for her to make?
Well, my lord, I and indeed the learned judge didn't conceive of this colour coding. That's the approach that TfL chose to take. That's how they set out to fulfil their public sector equality duty. And the equality impact assessment was of their devising so that they could fulfil their statutory obligations.
So it was a matter for them?
Well, the simple point is, my lord, they didn't comply with the rules of their own assessment.
When they refer in the colour coding to identified groups and effects on identified groups.
Yes. This may create a barrier that prevents someone from completing their journey.
Yes, but you have to read the whole thing, don't you? You have to read the whole note.
Well, there's nothing in line 7 that indicates that we're only going to give it an amber coding because.
All right, now, I don't intend this as a pun, but how much further do we have to travel? What points have you not yet covered in your submissions?
There's legitimate expectation and there's rationality, my lord.
Yes, right. Right. Let's break off now. Resume at 2:50.
If you please, my lord.
All rise.